Good morning, this is your Kelso Report for Friday, October 5th, and I'm your host, Clark Kelso. We have 4 California cases today, the first involving the enforceability of a broad limitation of liability clause in a contract between 2 businesses. The second involving the scope of California's anti-SLAPP statute. The third involving the appealability of an acquittal in a criminal contempt proceeding. And finally, a case arising under CEQA and involving a project to deliver a lot of additional water to a casino. First, we begin with the enforceability of a contract limitation. In a contract between 2 merchants of roughly equal bargaining power, courts will usually enforce limitation of damages clauses, since the perils of unconscionability and overreaching are usually absent in such contracts. The most common such clauses limit liability for consequential damages, such as lost profits or lost goodwill. That was precisely what the 2nd District faced in Food Safety Net Services versus EcoSafe Systems, where a company that manufactured cooking equipment for fast food restaurants engaged the services of a testing company to try to prove that their equipment did a better job than others in reducing pathogenic bacteria from tomatoes and lettuce. When the buyer failed to pay for the testing after it had been conducted, the testing company sued to recover the $10,000 fee it was owed. The buyer responded by filing an action for breach of contract and negligence, asserting that the testing company's results had caused the buyer to lose business. The 2nd District agreed with the Superior Court that these claims for damages were barred by a limitation of liability clause in the testing contract, and the buyer's claims were dismissed on a motion for summary judgment. In addition, although the buyer claimed that it suffered lost profits as a result of the study, the buyer was unable to come forward with any evidence supporting that allegation. It appeared instead that the buyer had filed its cross-complaint without any justification, just as a bargaining ploy to undercut the testing company's claim for payment. The only thing this strategy accomplished was to drive up attorney's fees on both sides, which the buyer ultimately had to pay because of an attorney's fees clause in the contract. So instead of just paying $10,000 for the services they received, the buyer ended up having to pay a total of $75,000 to the testing company, plus whatever they paid to their own lawyers. A bad day for the buyer. Next, we turn to California's anti-SLAPP statute. About 20 years ago, we saw in California a rise in defamation actions that were brought essentially in retaliation for the defendant's public participation in matters of public interest. In order to weed these lawsuits out for more legitimate defamation actions, the legislature enacted a statute known as the anti-SLAPP law, which creates a special process in defamation cases for early evaluation of the likely merits of the plaintiff's case. The acronym SLAPP means Strategic Lawsuit Against Public Participation. Now, for the anti-SLAPP law to be triggered, the defendant must show that the plaintiff's complaint arises from the defendant's exercise of his or her constitutional rights of free speech in connection with a public issue. If this first test is met, then the plaintiff must establish a probability that his or her claim will be successful on the merits. Well, over the years, the courts have given a very expansive, I would say too expansive, interpretation of what constitutes a public issue. And that appears to me to be the problem with the 4th District's decision in Chaker versus Mateo. The plaintiff and the defendant had a brief romantic relationship that resulted in the birth of a child to the defendant. They subsequently had a contentious paternity and child support suit. The defendant then posted a series of derogatory statements about the plaintiff and his medical forensics business on a number of websites, and that resulted in the filing of a suit for defamation. The 4th District concluded that the defendant's postings were in connection with a public issue, even though the postings were motivated by an entirely private dispute between the plaintiff and the defendant, they really had nothing to do with the plaintiff's forensics business. The court's reasoning was that the postings constituted consumer protection information that customers of the plaintiff's business might have an interest in knowing. The court then proceeded to the second step of the anti-SLAPP analysis and, I think, correctly concluded that the statements were statements of opinion and therefore constitutionally protected. I remain concerned, however, that the anti-SLAPP statute has been interpreted so broadly that it now applies to virtually every claim of defamation. In other words, the statute is no longer anti-SLAPP, it is anti-defamation. Next, we have a remedies problem in criminal contempt. This case here involves the enforceability of the terms of a stipulated injunction that arguably goes beyond what state law authorizes, and the question of whether a judgment of acquittal in a non-summary criminal contempt proceeding is appealable. Let's deal with the appealability question first. In Wonky Industrial, Commercial, and Residential v. Superior Court, the 4th District held that the Fifth Amendment's double jeopardy clause applies to non-summary criminal contempt proceedings. So, an acquittal in a criminal contempt proceeding is final and may not be relitigated. Accordingly, the 4th District reasoned an acquittal is not appealable. The enforceability issue in the case involved a stipulated injunction between the parties which ended a lawsuit arising out of a non-competition agreement and misappropriation of trade secrets. Now, the stipulated injunction arguably went beyond California law by restricting the defendant, a former employee of the plaintiff, from soliciting customers whose names were listed on a document attached to the injunction. Under California law, broad non-competition clauses are generally not enforceable. And given that rule, a former employee cannot generally be restricted from contacting customers of the former employer unless the solicitation involves misappropriation of a trade secret. The stipulated injunction did not include the restriction that the customer solicitation involved misappropriation of a trade secret, so the stipulated injunction was arguably invalid. However, the 4th District held that the invalidity of a stipulated injunction of this sort is not a defense in an action to enforce the injunction. As the court noted, it would be most unfair for the defendants in the underlying action to stipulate to an injunction that identifies certain customers whom they will not solicit in order to resolve claims that they misappropriated trade secrets, and then proceed to violate the stipulated injunction and defend against its enforcement by claiming that the customer list is not a trade secret and the injunction is not enforceable. In short, having made their bed, they must lie in it. Finally, we have a CEQA case. When government entities authorize construction projects, they are, of course, subject to the requirements of the California Environmental Quality Act, known as CEQA. The purpose of the Act is to make sure that the agency has properly considered all of the material environmental impacts of the project, and it is designed to give the public broad access to the information gathering and analytic process. Not all construction projects are created equal, or require the same degree of environmental consideration. Among other things, CEQA provides for a number of so-called categorical exemptions, where a full-blown environmental impact report is not required. In Voices for Rural Living v. El Dorado Irrigation District, the 3rd District reviewed a project that had been approved by the El Dorado Irrigation District pursuant to a categorical exemption for small construction projects. The project arose out of an agreement to provide water to a casino located on tribal land held by the real party in interest Shingle Springs Band of Miwok Indians. The project was small in the sense that it did not involve a lot of construction work to move a water main and provide some additional water to the casino. However, the issue before the court was whether the project nevertheless was subject to an exception to the categorical finding for, quote, unusual circumstances, close quote. The Third District agreed with the Superior Court that unusual circumstances existed here because, although the project did not involve a lot of construction, the amount of water being delivered to the casino jumped 500 times, a huge increase with potential environmental impacts on water availability in the area. The Third District ordered the Superior Court to send the case back to the Irrigation District so that it could decide how best to proceed under CEQA. And that's it for today's Kelso Report. Have a great day in the law.